you that you, again, allow GWA to pursue this legislation that we have been able to get introduced so that we can have the law, a law that gives us legal comfort that we can actually borrow the $20 million that is required.
The authority would be taking a risk that borrowing for this purpose and charging its ratepayers for these purposes would constitute the transfer of an unfunded mandate to the authority.
Despite warning that approving a proposed order to force the Guam Waterworks Authority to reimburse the general fund from its 2010 bonds would be illegal and in violation of bond covenants, the Public Utilities Commission last night voted in favor of Administrative Law Judge David Mayer's recommendation to follow Public Law 30-145.
As an administrative agency, our sole function is to enforce the laws upon as enacted. I do not believe that ordering GWA to pay this money is going to violate any federal order that I've seen, because I have not seen a federal order that says what to do with the 2010 bond proceeds.
I would like to move that we accept the ALJ's order as written and appreciate item number 3 to have an investigation done of the rates.
All in favor say aye.
Aye.
The motion carries.
Senator Ben Pangilinan says the order is a victory and doesn't believe the payment would require any additional rate increases. Instead, he's just happy the government will eventually be able to use the money to pay tax refunds and COLA.
There's a death in the family. There's somebody that may die in the family if they don't get them off island for health care. And this is what we grant these emergency tax refunds for. And that's what this legislative body would like to make this reimbursement available for.
But CCU Chair Simon Sanchez says the PUC's decision basically requires GWA to do something illegal, which leaves the commission with several options that include an appeal directly to the Guam Superior Court or going to the district court.
We may actually go to federal court and ask them to take a look at it, because this ruling is going to affect our ability to comply with the federal court order, or we could do nothing. We are going to still pursue Bill 222, which has been introduced by Senators Ada and Respicio, which would allow us to borrow the money in a way that we think is legally allowed.
Sanchez says should tax refunds and COLA be addressed with the governor's version of the borrowing bill, they may seek a repeal of the public law, saying this is a piecemeal way of solving the problem of paying debts owed to residents who are also ratepayers.
Why are we having the people of Guam pay $70 million for $50 million of infrastructure they've already paid off? It's also going to require a rate increase. Debt service on a $20 million loan is $2.5 million a year. That's got to come from someplace. We could be using that money to fix something.
The Consolidated Commission on Utilities will discuss their options further during their next regularly scheduled meeting, which is set for next Tuesday, June 7th. Reporting for Guam's News Network, I'm Mindy Egan.